So, for example, there's a situation of occupation, one in which humanitarian law applies, or one in which human rights law is more applicable. And I think it seems to be, the consensus seems to be converging on how tranquil is the occupation. If it's a calm occupation, then human rights law will be in the ascendant. And if it's a belligerent one, a situation of conflict, then humanitarian law might be more relevant. A few words on procedural issues, and then I'll wrap up. Human rights law has a more sophisticated framework, as we've seen with the treaty bodies and the jurisprudence and the rights of international standing. Let's look at some of the implications of this. Firstly, let's take the question of investigations. In human rights law, an investigation is required when any serious human rights violation has occurred. It must be official, it must be prompt, thorough, and independent. And there must also be an adequate level of transparency surrounding the investigation. And investigations have indeed been applied by human rights bodies to situations of armed conflict. I mentioned Liberia and Sierra Leone a while back. But there are some, including the UN Special Rapporteur on Extrajudicial Killings, who feel that the standards for investigations in these situations are often less stringent in situations of armed conflict than in situations of peace. So this requires us to consider how human rights law might be able to influence further the conduct of investigations in armed conflict, the extent to which we need, it's our obligation to ensure that these investigations, even in conflict, are carried out with a rigorous methodology that's in accordance with human rights law. Or we could look at reparations. We've seen that there's no individual right to reparations in humanitarian law, unlike human rights law, where in the latter instance, the right to claim reparations lies with the individual. But there's nothing in international humanitarian law specifically precluding the right to a reparation. And indeed, many violations of that code would also constitute violations of human rights law. So I think there's an increasing need as well here for states to afford such a right to reparations for violations of humanitarian law, just as much as for human rights law. And indeed, this is now explicitly recognized in the Rome Statute setting up the International Criminal Court. A few words in conclusion, then we can have a chat. One is the pretty general acceptance now that there is parallel applicability of humanitarian law and human rights law. And secondly, that international human rights law can have extraterritorial applicability, which is a very relevant consideration when looking at international armed conflict and situations of occupation. The most complex aspects of this discussion concerns, I think, the nature of the cohabitation. When is one law more applicable than the other, and how can the two bodies of law effectively feed off each other? There are clearly tensions in how each body of law views the use of force. Humanitarian law notions of military necessity and collateral damage don't sit easily in the context of human rights law, most obviously. So I think the key is to try and devise a means, as I said at the outset, by which to ensure that there is an appropriate balance between security needs, and let's not forget, when we talk about security needs, that we're also talking about a human right, a right to security. But we need to balance those needs with individual liberty. And I would argue that the former must be viewed in such a light as to give the broadest possible scope to the attainment of human liberty in its fullest sense. In 2005, in one of his last major acts of his Secretary Generalship, Kofi Annan observed that when it comes to laws on the books, no generation has inherited the riches that we have. We are blessed with what amounts to an international Bill of Rights, amongst which are impressive norms to protect the weakest amongst us, including the victims of conflict and persecution. But without implementation, our declarations ring hollow. Without action, our promises are meaningless. So these then are perhaps my final comments, that discussions of the compatibility or otherwise of humanitarian law and human rights law are undoubtedly important. We must all seek to attain legal clarity. But in doing so, I think we shouldn't overlook either the fact that both codes share guiding motivations to protect the dignity of the individual, and nor should we forget that as important as legal clarity is, so is the need for the law in question to be respected and, where not, enforced. So here questions I think need to be asked not so much of UN bodies or international fora or legal academics, but rather the questions need to be asked of the states themselves and their citizens, of their commitment to ensuring that the necessary monitoring mechanisms are in place, that advocacy is allowed to flourish, and that the necessary political will is there to prosecute individuals at the national level.
Thank you.
And thanks to Mustafa. Also thanks for your terrific lecture. And on behalf of the department, please see our token. Press go on. I already prepared one, so because I'm not aware of your around.
Can I open it?
That's up to you.
No, in Indonesia you don't always open presents.
And guys, there will be another lecture series in 3 weeks' time. There will be a Japanese officer, lawyer, who will present something in regard to the criminal law. So I hope that you can also join us and chill. Thank you very much.